කල්තැවීම
19 බ්‍රහස්පතින්දා පෙරවරු 10:30 දක්වා සභාව කල්තැබිය යුතුයි යෝජනා කරනවා.
කල්තැබීමේ යෝජනාව Honorable Sampanthan to make the agent motion.
Thank you, Mr. Deputy Speaker. If I might commence by reading my motion. This motion, sir, pertains substantially to persons held in custody from the north and the east under the Prevention of Terrorism Act. The facts are as follows. These persons are held in custody under the Prevention of Terrorism law, irrespective of whether they have been convicted, have been charged, or have not yet been charged. They have been arrested under the Prevention of Terrorism law, and all action taken against them has been in terms of that law. It has been accepted by the Sri Lankan state both domestically and internationally that the said Prevention of Terrorism law is draconian, obnoxious, and should therefore be regarded as obsolete. The Sri Lankan state has made several commitments both domestically and internationally that the said law will be repealed and that a new law will be enacted in keeping with acceptable domestic and international norms. The Sri Lankan state is yet to fulfill its commitment, but that does not derogate from the Sri Lankan state's commitment that the said law should not remain on the statute book. The only evidence available against most of these persons are confessions extracted from them against their will under the Prevention of Terrorism law, which would be inadmissible against them in a normal court of law. Many of the cases have been postponed because the prosecution is not ready to proceed with the cases. Almost all of them have been in custody for very long periods of time, for as long as they would have been sentenced if sentence was passed on them shortly after being taken into custody. The families of these persons in custody have suffered for very long periods of time without the support of their breadwinners. This vitally important factor has not been given due consideration. Quite apart from the pernicious nature of the Prevention of Terrorism law, persons in similar situations, such as persons taken into custody during the insurrections of the JVP, have been granted an amnesty and released. It is not understood why the same principle cannot be applied in regard to these prisoners. These cases cannot be considered as coming purely under the purview of the Attorney General's Department. With due respect to the Attorney General, as the Chief Legal Advisor of the state, these cases have a certain political dimension and cannot be addressed on a purely legal basis. It can be justifiably stated that if Sri Lanka's national question had been reasonably addressed in time, many of the persons in custody would not have been in their present position and would have been useful citizens. This circumstance makes it obligatory that you address this issue politically too. It should not be addressed politically. It is a strong impediment to reconciliation and restoration of goodwill and harmony. An unnecessary complication has been created by the transfer of some cases from Babunia to Anuradhapura. If witness needed protection, such protection could have been provided with all the cases being transferred. accused in the cases to be transferred from Babunia, where the language of the court is Tamil, to Anuradhapura, where the language of the court is Sinhala, are from the northeast and are Tamil speaking and not proficient in Sinhala, the other language of administration and courts. There are cases being transferred to Anuradhapura, where the language of the court is Sinhala, is a denial of their constitutional right to have their cases heard in Tamil, a language which they can understand. In a criminal prosecution, the rights of an accused person are fundamental. He has a right to fully comprehend the evidence and the case presented against him. By such transfer, the accused are also denied the opportunity and the right to legal assistance of his choice. These and other factors could prejudice a fair trial. The proposed transfer reflects a measure of insensitivity to the fundamental rights of an accused person. The prisoners have been continuously carrying on a fast against such transfer. The situation needs to be addressed on an urgent basis. I have to also very strongly urge that for the reasons stated above, all these prisoners be released without any further delay. Mr. Deputy Speaker, if I might say a few words in regard to this motion. The main points of the adjournment motion, sir, are all these persons, whether convicted, prosecuted or not prosecuted, have been dealt with under the Prevention of Terrorism law. They have been arrested, investigated, charged, and trial proceedings conducted and convicted under the Prevention of Terrorism law, which the government itself admits must be repealed because its provisions are such as to raise the question whether such provisions can ensure justice. The law is to be repealed for the reason that the implementation of various obnoxious provisions in the law can only result in injustice and not justice. This is the primary reason for the government wanting to repeal the law. This is the reason for my submission that all these persons must be released. Whatever the stage of the cases against him may be. I might read to you, Honour, sir, the commitment made by the government at the United Nations Human Rights Council in the resolution adopted on the 1st of October 2015. The resolution states that the United Nations Human Rights Council welcomes the commitment of the government of Sri Lanka to review the Public Security Ordinance Act and to review and repeal the Prevention of Terrorism Act and to replace it with an anti-terrorism legislation in accordance with contemporary international best practices. That is the commitment made by the Sri Lankan government to the United Nations Human Rights Council in regard to the repeal of the Prevention of Terrorism law. These persons, sir, have been in custody for long periods of time, 10, 15, 20 years, which would mean that they've already been in custody for periods equivalent to that for which they would have been sentenced if they were sentenced shortly after they were taken into custody. It will be unjust to continue to keep these persons in custody. It cannot be disputed that these persons have engaged in certain activities for political reasons or purposes. These cases have a political dimension. It was the failure to evolve an acceptable resolution to the national question that resulted in these persons engaging in certain activities that constitute the offences that they are being charged with. It has a political dimension. It is not a purely legal issue. If it has a political dimension, different considerations must apply, particularly in the present context when reconciliation has become the key issue facing the country. It is imperative that the issue must be also addressed politically and not looked at as a purely legal issue. This issue not being addressed expeditiously is a serious impediment to reconciliation, where the accused persons and those sharing a commonality with them feel that they are being treated differently. During the JVP insurrections in the 1970s and 1980s, persons accused of grave offences were granted amnesty and freed. The gravity of the offences committed was about the same. There was a political dimension. That is why they were granted an amnesty. Accused persons want to know why they are being treated differently. This different treatment constitutes a serious impediment to reconciliation. The families of these persons in custody have been without the assistance of their breadwinners for long periods of time. They have undergone immense suffering, and that too is a serious impediment to reconciliation. An unnecessary complication has been added to the issue by 3 cases being transferred from Babunia to Anuradhapura. These cases have apparently been transferred to ensure the safety of witnesses. It is strongly submitted that the safety of witnesses could have been ensured without the cases being transferred. Consequently, the prisoners concerned are carrying out a fast, and the condition of their health has become a matter of concern. These are Tamil prisoners from the northeast who have a knowledge of Tamil only and do not have a knowledge of Sinhala. The language of the courts in Babunia is Tamil, but the language of the courts in Anuradhapura is Sinhala. As per the constitution, that is the position. Accused persons being Tamils without a knowledge of Sinhala are constitutionally entitled to have their cases heard in Tamil in a court where the language is Tamil, and their cases being transferred to Anuradhapura, where the language of the court is Sinhala, is a violation of their constitutional right. As accused persons, they should not be denied the right to fully comprehend the entirety of the case presented against them. Transfer of the cases to Anuradhapura, where the language of the court is Sinhala, denies them that right. By such transfer, they are also denied legal counsel of their choice. These factors are tantamount to a denial of justice. The prisoners concerned also ask that the decision to transfer their cases to Anuradhapura from Babunia be rescinded. And I do urge that all persons taken into custody under the Prevention of Terrorism law be released. Mr. Speaker, before I conclude, I would like to say a few things. There is a strong feeling amongst the Tamil people that these prisoners who are in custody under the Prevention of Terrorism law, and they are in custody because they have committed certain offences related to the resolution, related to the non-resolution of the national question. All these persons are being charged for various offences committed because there was a conflict in this country between the people who constitute the people of this country. They are not persons who are alleged to have committed offences for personal benefit. There was a political dimension to it. And when there was similarly an instance earlier on in the 1970s and 80s, when there were the JVP insurrections, which also had a political dimension, more economic than social or political. There was a political dimension. All of them were granted an amnesty, and they were freed. I observe the Minister for Law and Order is here. I believe he is the one who is going to answer this question. We do not want to confront the government, but we certainly want to impress upon the government that the time has come for you to seriously address this question. It is not sufficient to say there are no political prisoners. This issue has a political dimension. All these persons are in custody, all these persons have been charged, and all these persons continue to be in custody because they have committed certain offences consequent to there being a conflict in this country in regard to the nature of governance, in regard to the structure of governance. That's why they are in custody. So you can't deny that these persons are in custody in relation to offences which have a political dimension. And that makes it obligatory for you not to look at this as a purely legal issue. It is not merely an issue for the Attorney General Department. It's an issue for the government to handle politically, to address politically. And these prisoners quite rightly say, if in the 1970s and the 1980s, when there were JVP insurrections and very serious crimes were committed, serious offences were committed, but there was a political dimension. They were given an amnesty and they were all freed. So I don't think, sir, the government should any longer look at this question in a manner that doesn't befit the seriousness of the question. I think the time has come for the government to address this question seriously, because the Tamil people, Tamil prisoners, and the Tamil people feel that the government is not addressing this issue seriously enough to come to the right conclusion. So we would appeal to the government. I appeal to the government on behalf of these prisoners. I met some of them, I met their families. Families are suffering. They've been in custody for 10, 15, 20 years. If they were sentenced shortly after they were taken into custody, they would have finished their sentence and come out by now. They're not able to do that. And in regard to the prisoners transferred from Babunia to Anuradhapura, you are denying them their constitutional right to have their case heard in Tamil, which is a provision that is provided for in the Constitution. And they have a right to have their case heard in Tamil. I mean, their case being transferred to Anuradhapura is not fair, is unjust, is unacceptable, and therefore I think that order should be rescinded. I would earnestly look at the appeal to the government. I make this appeal especially before the minister answers, to give this question very serious thought and kindly address this issue in a manner different from which this issue will be addressed hitherto. Thank you, sir.
Honorable